President David Mushiki, Manuel Chair, Maura Kabak.
Yes. I think we are done with the program unless somebody's name has not been recorded. I believe that you are ready to take the ruling as well as the applications which we had yesterday. This is the ruling in the consolidated applications, in the consolidated petitions. We have considered the submissions of the parties, the facts in those applications, and the arguments and submissions of parties, and we have prepared a ruling which will be perfected in the course of the day, but in summary is as follows. We have given the facts of the proceedings, the relevant submissions and arguments, and for the purposes of today and this morning, because we don't have much time, we'll give you the abridged version of our ruling. Analysis, having carefully considered the applications, the responses, party submissions, and the various decisions referred to, the court distills the following issues for determination. 1. Whether the applications are res judicata. 2. Depending on one above, whether the applications are merited. As to whether the applications are judicata, the nature and applicability of the doctrine of res judicata is a well-trodden path by the Kenyan courts. In petition numbers 42 and 43 of 2014, which were consolidated, that is Kenya Commercial Bank Limited versus Nuri Coffee Estate Limited and another, the Supreme Court of Kenya, in an elaborate fashion, illustrated the operation of the doctrine of res judicata. We are not going to go into the details about the doctrine of res judicata, but we have considered it there. We have cited several cases in support of the arguments put forth by parties. And returning to the matter at hand, there is no contestation that the first petitioner herein regarding Gachagua filed and prosecuted an application seeking conservatory orders in Nairobi High Court, constitutional petition number E 550 of 2024. On 15th of October 2024, His Lordship, Judge Mwita delivered a ruling on that application. For reasons contained in that ruling, the application was dismissed. The nature of the conservatory orders which were sought in the said Nairobi High Court constitutional petition number E 550 of 2024 related to various facets of the impeachment proceedings against the first petitioner in this case before the National Assembly and the Senate. Likewise, the applications subject of this ruling also challenged the very pending impeachment proceedings. Learned Senior Counsel Mr. Paul Mute urged this court to nevertheless deal with the instant applications for the main reason that this court, as constituted, is an expanded multi-judge bench of the High Court as opposed to the ordinary single bench. The respondents did not, however, find favor with the above position. It was vehemently contended that the instant applications ran afoul the settled doctrine of res judicata. This court has diligently addressed itself to the above arguments. Unfortunately, we did not come across any holding persuasion that a decision of an expanded multi-judge bench of the High Court of Kenya is superior to that of a single judge. This court therefore finds that the challenges raised in the instant applications are similar to those dealt with in Nairobi High Court Constitutional Petition number E 550 of 2024. In applying the tenets of the doctrine of res judicata to this matter, we have no doubt and do hereby find and hold that the applications herein are in four corners with the one dealt with in Nairobi High Court Constitutional Petition number E 550 of 2024. The applications are hence caught up by the doctrine of res judicata. For clarity, the issues raised in the applications before us were fully canvassed by a court of competent and concurrent jurisdiction. Having found as such, and for abundance of caution and the completeness of the record, this court will still consider the second issue, and that is whether conservative orders ought to issue. As a well-settled principle law, a court dealing with an interlocutory application seeking conservative orders is called upon to exercise restraint and to resist the temptation of making final findings at such stage. We have cited cases or authorities emanating from the Supreme Court on that matter. Therefore, a court exercising jurisdiction in an application for conservative orders must sustain that delicate balance by ensuring that it does not delve into and determine issues which largely fall within the realm of the main dispute. The nature of conservative orders was discussed in the Supreme Court of Kenya Civil Application number 5 of 2014, Gatirao Peter Munya versus Dixon Mwenda Githinji, and I have stated what the court said. It was also discussed in other cases which we have referred to in this. On the principles to be considered by courts in dealing with applications seeking conservative orders, the locus classical case of Gatirao Peter Munya, which I have said, comes to fore. And we have delved into what the court said in that case. We have also cited the case of Board of Management of Uhuru Secondary School versus City County Director of Education. We've also